SJC-12007, Commonwealth versus Etnid, Lopez.
Ms. Doherty, good morning.
Good morning. May it please the court, Elizabeth Doherty on behalf of Etnid Lopez, the appellant defendant in this case. This case presents a number of issues. I'm going to try to get to some of them this morning. I would like to start out with the motion judge's denial of the new trial in this matter. At the outset, I would note that where the motion judge in this case was not the trial judge and where there was not an evidentiary hearing, this court is in as good a position as any to determine the propriety of the denial and grant a new trial in this motion. In the alternative, if this court does not grant a new motion for a new trial, I would submit that the matter should be remanded to the trial court for an evidentiary hearing in this matter.
So can you tell me what facts you had that would have warranted an evidentiary hearing? And what that would have achieved for you and your client?
Well, in this case, there would have been an expansion of the new witness's testimony, and most particularly a determination of her credibility. Not only does the Commonwealth, but the motion judge, made some suggestions as to her credibility, and so that would be expanded at an evidentiary hearing, and I would submit that that would be crucial in this case. Although, as I would state, I believe that this court can grant this a motion for a new trial on this record. There is her statement, and then there are also her statements and the circumstances from the Pennsylvania shooting, which I would suggest are extremely probative.
Can you expand on that? Because isn't the theory of the Commonwealth that both Garnham and the defendant were involved in the shooting?
The stabbing.
That's the Commonwealth's theory, right?
Well, no, in fact, it wasn't really the Commonwealth's theory at trial. The Commonwealth's theory at trial was not that that Jared Garnham was involved. They acknowledge, and the evidence shows that he was there. But the theory at trial was that it was with J.C. Lopez, which this court heard recently, and with Irving Cruz, who was his uncle. There was no dispute that Jared Garnham was there, and I would allow that during the closing argument there was a passing statement that they said, well, even if Jared, if Jared was involved, it was joint venture. But that was not their theory at trial, and they did not present evidence in that. I believe I have a notation to that particular passage in the motion for the new trial. But that was not their theory, and my position would be that the Commonwealth, if they want to retry this case, they can try it on that.
I guess I still don't understand what her testimony, had she testified, what really that would have added to your client's case.
That testimony would have added, I would submit, it would be crucial. Her testimony, her statement, but then also incorporated in, as they say, her statements during the interviews after the police shooting. Her statement was that he bragged about stabbing the individual, Tegan Hollingsworth. In her statement to the private investigator, she stated that he cut off his hair, and that was part of a group that was there, but that he was the one that stabbed that Tegan Hollingsworth. There was certainly, and the motion judge cited this as a reason for denying the new trial motion. There was other evidence at trial, third-party culprit evidence, and he found that that was cumulative. I would submit that this particular evidence that that we're proffering makes that corroborates and bolsters that new trial motion, the third-party culprit evidence at trial. Because her particular statement, this new evidence is different in kind than the third-party culprit witnesses that were submitted at trial.
But again, there were several people involved, right? So what does it add to say that Garnham was also involved?
The defense theory, and the defense theory that in terms of submitting the motion for the new trial, is that Jared Garnham stabbed Tegan Hollingsworth independently, unilaterally, not as part of a joint venture, and that in order for Etnid Lopez to be convicted as a joint venturer, he would have had to share that intent.
But didn't Ashley say that he said we killed?
Well, that particular statement comes from one of the police reports, and the motion judge sort of honed in on that particular statement. At the outset, I would submit that witnesses, and this comes from Commonwealth versus Hampton, that's quoting Commonwealth versus Hill. There are generally inconsistencies and variations and discrepancies in their testimony, and they may not be completely helpful. But that in her statement to the investigator, she said that he bragged about stabbing that individual. And again, this is consistent with the defense theory that Jared acted independently, not as part of a joint venture.
Well, I mean, isn't it more precise to say that the evidence was overwhelming, that your client was involved at a minimum in a joint venture to assault and batter the victim?
Thank you.
But that if the stabbing had been done by Mr. Garnham, then the Commonwealth would have to address the issue of whether or not your client knew that he had a knife and shared the intent to kill him, as opposed to beating him to a pulp.
Exactly. That in order to convict my client as a joint venturer, he would have to share the intent, not to batter and beat, but to kill. And that Ashley Springs' testimony and also the sort of surrounding circumstances from the Pennsylvania shooting tend to corroborate the third-party culprit defense and third-party culprit witnesses that were submitted at trial. You have Jai Brown Garnham, who testified, and it came in both through his testimony but also through Trooper La Liberty, that he was stabbing Tegan Hollingsworth, and the others thought that he was punching him, but they didn't know that. And so that particular, her testimony, the Commonwealth suggests a number of times that this particular evidence is not exonerating, and I would submit that that injects a requirement that's not required for a new trial motion, either based on ineffective assistance of counsel or on whether it's newly discovered evidence. But that would have been a factor that the jury would have wanted to know, particularly because they heard third-party culprit evidence.
Can you remind me, because I'm getting the two cases confused, and I don't know what the testimony was in Etnid Lopez's case, but was there testimony that he had a knife in the parking lot in his case?
That Etnid had?
Yes.
There was one witness
Yes.
that testified that he was seen with a knife. That was Amari Thompson, and she wasn't able to describe the knife. She just said that she saw a knife. Her testimony that he was holding the knife in sort of a Statue of Liberty pose was not borne out by the video in this case. But yes, there was one witness who did testify in the parking lot.
Right, and chasing the victim with a knife in the parking lot.
chasing, that was her testimony. That it was not borne out by other witnesses, but she was one witness who testified in that manner. He was not seen with a knife in the backyard. None of the witnesses saw anything in his hand. None of them saw it in any of their hands. So yes, I would have to certainly concede that there was testimony at that point. But that's not where the crime took place. The crime took place in the backyard.
Just to be clear, there was no break in the action, right? There was a chase that eventually led to the backyard. Is that how the evidence came out?
What do you mean a break in the action?
Well, he was seen running around the parking lot with a knife. The chase left the convenience store.
Well,
The chase left the convenience store, and the group ran down the street into a driveway and into a backyard. So that was the order of events, right?
Well, that is correct. There was actually a break in the action in that, and this is not contested, but that after that initial chase took place, Edward was restrained by Michelle Torrey, held there, and then at some point broke free. At that point, there was no evidence as to seeing the knife, and I would submit that Amari Thompson really only observed this for a very short period of time. She saw her cousin running around. She saw this short chase, but she didn't see anything later on. The evidence is that she looked at it quite quickly and then drove off. Not particularly, I guess, being concerned with her cousin being chased. But so as I say, there was a break in the action between.
I guess we can quibble about whether that's an actual break. I mean, the victim was still running away.
Well,
and your client eventually, broke free within a matter of seconds.
Yes, but I guess in terms of there being consistent evidence of him being seen with a knife all on, there was her testimony that he was seen with a knife, and then there was a break in that, and that there was no further sightings of it at that point. But I guess I would get back to the point of the probativeness or materiality of this particular evidence. Ashley Spring was, a completely disinterested witness who was hundreds of miles away, but still knew details of this that she could only have learned from Jared. And then when you factor in on top of this, the context in which his shooting took place, you have Ashley Spring in the police statements stating that on the way she could only hear one side of the conversation, but that she believed that he was receiving telephone calls which were suggesting that he would now be be suspected of or charged with the homicide. And then you have him going to the bus station and deciding precipitously that he's not going back, and then all hell breaks loose. I would submit that his concern with being charged in the homicide is consistent with the timing of Jai Brown's statement. You have Jai making a statement in March of 2011. He did not testify at the first trial. He did not testify at Irving Cruz's trial, which was the first one that took place. And then you have Jai making another statement on December 6, 2013, just on the eve of J.C. Lopez's trial, 2 days before Jared is to head back to Massachusetts to be a witness. And on the eve, and that's consistent with or corroborates Ashley's perception that he was getting phone calls and was suspected of being charged in this homicide.
with regard, if you can turn to the statement with regard to the invocation of silence of Mr. Lopez.
Oh, the motion to suppress.
Motion to suppress. Was there any objection? I gather the jury heard both the invocation of silence, which now the Commonwealth concedes should have caused the discussion to stop. Did it also hear the later invocation of silence, which did end the interview?
No. In the record appendix, there is the order of redaction, so you can follow through and see. And then I think also in the copy that I submitted as part of the record appendix, it's sort of not officially, but it's sort of marked off. But getting to the...
So your claim that it's not, as the Commonwealth contends, harmless beyond a reasonable doubt...
Absolutely.
...is focused in part on the fact that they heard the invocation of silence.
Absolutely, yes.
What else? She argues ably, as she often does, that there was nothing there that didn't come in through other sources or that was not earlier stated by him before the invocation of silence. Can you address that?
Sure. These are, as I would say, I think that particular statement that you just alluded to, or didn't allude to, that you just stated, is the most prejudicial before the jury. But he identified at that point, after the post-invocation statements, which went on for about 50 minutes. He identified himself on the video and as chasing Tigan. He acknowledged his hair was in braids, but he had taken them out. He denied he had a nickname when earlier he had said that it was easy, and that was actually cited in the closing argument as well. He identified himself as wearing a white T-shirt when in fact he had not before. He admitted in response to the police officer's statements that he was getting pretty hot there. This is all from the reply brief that I've cited. He responded to a detective statement that he was starting to get a little scared. All these statements are prejudicial, and they use them for, consciousness of guilt as far as his lying. I would just sort of back up before the post-invocation statements and state that my position is that the entire statement should be suppressed because his being transported to the Taunton police station, consistent with or in keeping with Commonwealth versus Mello, was not consensual. It was a de facto arrest, and there was not at that point probable cause to arrest him, and that because of the things that took place afterwards, sort of the taint of that was not purged, and not only that, his Miranda waiver was not consensual either, or was not voluntary. Because of a number of factors, his youth, and I cited a number of studies with respect to that, but also the trickery and deception that the police officers employed. The fact that, and he was at that point 17 years old, and the interested adult rule, I would concede, did not apply at that point, but his mother had asked a number of times to come and accompany him. And so he was alone, he was 17, he was subjected to trickery and minimization on the part of the police officers. Not only that, the motion judge on the motion to...
Minimization? I mean, I know that they said he was not a suspect, but they were not minimizing what he did.
They were not...
Usually minimization is,
Yes.
you were just acting in self-defense, I'm sure, or everybody understands why somebody would act this way.
That's right. I mean, I'm not, I guess I'm not using minimization, and I'm using it sort of in the more colloquial way or whatever. They minimized the need for Miranda rights. They minimized the fact that he had an option to have his interview recorded or not. I take your point. I'm not using it in terms of the term of art, the court, but they did minimize the importance of all of these things. And that played into his youth, which, again, I would take great issue with the fact that and I have filed a motion to have the video transmitted from the trial court. But I would take great issue with the fact that the motion judge said he seemed cool, calm, and collected. He seemed, mature beyond his years or whatever. I'd point to the studies that I cited, one in particular in the reply brief, where juveniles may have a cognitive understanding of this, but their juvenile status tends to bear heavily on their ability to make decisions, and their ability to make decisions in this kind of I think it's been called like a sort of a hot type situation. And then again, the particular study that I wanted to point to was that juveniles tend to have an overconfidence of their ability to be able to navigate these kind of situations. And they, again, not only that, looking at short-term goals, like I want to get out of here, rather than the long-term goal in terms of what is this going to do. And I see that my time is up, but I would just point out in one of the footnotes in the reply brief, there has been a suggestion on the part of, I believe it's the American Psychological, it's in a footnote in the reply brief, stating that for all juveniles, including those 17, they should just consistently have a lawyer present with them during these kind of proceedings. And with that, I rest on my brief as to the other issue.
One last question, unless others do. Did the motion judge rely only on the videotape of the interview? I mean, are we in the same position as the motion judge? Or
yes, I believe that yes, I believe that's correct. If I find that in fact that isn't correct, I will submit a letter to the court. But I believe that's correct.
Thank you. Ms. Johnston.
Good morning, Your Honors. May it please the court, Tara Johnston for the Commonwealth. Before I get into the issues, I want to clarify, were you asking the motion to suppress judge? Did he just rely on, actually there was a suppression hearing at which Detective Spencer, I believe, testified, and then it also the defendant's mother testified. So the motion to suppress the motion to suppress judge also based his ruling on the hearing, the testimony that he heard from those witnesses.
Was that the police officer who conducted the interview?
Actually, I believe it was the police officer who went to the defendant's home. He was one of the two police officers, Detective Spencer, who, and then he went with Officer Tracy, and they went to the defendant's home. And when they went to the defendant's home, they asked him if he would come with them, which of course isn't on the videotape that we have. So we needed it. That's why we needed the suppression hearing. And the motion judge found he credited the officer's testimony that the defendant came voluntarily, which actually makes this case distinguishable from the case my sister cites, Commonwealth versus Mello, because in that case, the motion judge did not credit the officer's testimony that the defendant came voluntarily to the station, and that was part of the problem. But here, the motion judge did find that the defendant came voluntarily, and that it was not a custodial interrogation, at least at that point. The Commonwealth does not contest that at some point during that interview, the interview became custodial, and the Commonwealth actually points to page 59. It's to where that happens in the interview, and it's where they suggest to the defendant at the point in that interview where they suggest to him that he is in fact a suspect. But before that point, the interview is not custodial. And also, is with respect to, I know my sister is saying that the entire interview should be suppressed, but also the motion judge found, he watched the video, and if this court watches the video, you'll see that it warrants the judge's conclusions that the police, they did make those false statements to defendant about him just being a witness. But false statements alone ordinarily, under Commonwealth versus Spray, citing Commonwealth versus Giambattista, ordinarily do not require suppression by itself. The court looks at the entire interview, and here, there were no other coercive tactics used. It was not aggressive. Although it's true the defendant was only 17, he acted like he did not act nervous, he did not act scared. He told the officers he was hungry on the way to the station, and they stopped for a donut and juice. This was not a situation where the police were trying to make the defendant feel, or at least it would not appear it from the interview, that they were trying to make him feel like he was being coerced into making statements or forced into anything. And all of their statements telling him, you're not a witness, we're just talking to a lot of people, are also suggestive of that. Now, of course, we have the issue, and clearly this is what the court is concerned with, is where, or most concerned is where the defendant invokes his right to silence. And unfortunately, that does come in. But now, the Commonwealth is not saying, Commonwealth has conceded in its brief that anything after that point was, of course, should have been suppressed, but that it wasn't prejudicial. The Commonwealth also does not contest that statement itself, I'm not talking anymore, should have been suppressed. However, even though it came in, I would say that it's not as prejudicial as my sister argues, and that's because of the context in which that statement was made. The statements that the cases that my sister cites in her reply brief, DePace and Benesh, are cases where the court was saying how it was improper for this, and of course it was improper, but that it was prejudicial to some extent to the defendant because in those cases the interview was ended at that point, or those were the last statements the defendant made. That was a clear invocation of the right to silence, and that's the way the jury would have understood it. They heard testimony, the defendant said he wanted to stop talking, and then that was it, silence. But here, that's not the context in which the statement is made. The defendant does keep talking after that. Now, even though the officer is the one to make the next statement, the context of the defendant's statements are not made in the context of, I want to stop talking because I know I'm guilty, I need a lawyer. That's his those are his last statements, which are redacted, or not, I'm guilty, but I need a lawyer. Those are his last statements, which are redacted at the end of the interview. But the statements that he makes when I'm done talking is, I'm done talking because you're not believing me. That's his sort of statements immediately before he makes the statement, I'm done talking. You're not believing me, I'm telling you the truth. And he keeps saying that over and over again, even after he says, I'm done talking. I'm done talking, I don't want to talk anymore, you're not believing me, I'm telling you the truth, 100%, this is what I'm telling you, and you're not listening. And then, after that, the officer says, well, do you want to see the video that we have? And he says, yes, he wants to see the video. So this is what the jury hears. So while the Commonwealth isn't arguing that it should have come in, I'm done talking, we have to look at it in the context of whether or not it was prejudicial. And here, the context in which those statements were made show that it was not it would not have prejudiced the defendant to the extent that my sister argues, and maybe not at all, because here really he was making it in the context of, I'm 100% innocent and you're not hearing me, and that's why I want to stop talking. And then he continues to talk. So now, with respect to the other statements my sister argues were prejudicial that came in after that point, him identifying himself on the video, there are other witnesses. Kayla Lawrence identified himself, the defendant, on the video. He was the only one at the scene with a white T-shirt. There was no question that the defendant was the one chasing the victim at Grampy's. He was the only one there in a white T-shirt, and there were numerous witnesses who testified to it. And Kayla Lawrence identified the parties from the video. So the fact that he is in that interview saying, that was me, honestly just shows that he was telling the truth, because there was the testimony that it was beyond overwhelming that was him. There was no question about his identification. And in terms of his statement that his nickname was not easy, one, I know my sister mentions that it was mentioned by the prosecutor in the closing argument, but actually I don't believe, and I apologize if I'm wrong, but we read the closing argument, and I believe that the prosecutor only mentioned the fact that early in the interview when the defendant concedes that his nickname was Easy. I don't think later he says, I don't think the prosecutor ever says that in that interview the defendant denied it as consciousness of guilt evidence. So I don't think it's used in that manner. I also don't think that it's as prejudicial as my sister argues, and that's because of the context in which that statement is made. Another officer, at that point when he says about not having a nickname, another officer has just entered the room, and that officer says, hey, what's your name? And he's like, Etnid, and he says, do you have something else I can call you? And he says, huh, and then he's a nickname, and at this point, it's far in the interview, and the defendant just says no, and then the officer says, okay, can I call you E? And he says, sure, or something to that effect. It's not said in the context of I'm denying that I have a nickname to any of my friends or that I ever go by the name EZ. It's not said in that manner. So we have to look again at the context. And anything that really came out in that second half of the interview that the defendant argues was extremely inculpatory, it was just denial, continual denials, and two, it was cumulative of what came out in the first half of the interview, which was consistent denials about his being in the backyard of 148 Ware Street, where the victim was stabbed. I will now go back to the first issue of the denial of the motion for new trial. And so here, my sister brought it as an ineffective assistance claim in her motion for new trial, arguing that the defense attorney should have, one, gotten the police reports regarding Garnham's murder, and two, that it was substantial evidence that would have deprived the defendant of a substantial defense.
You refresh my memory, was there an affidavit filed in the motion for new trial from trial counsel? There
was. And he said that he spoke with the defendant about it, and the defendant told him about it and wanted him to look at these reports, but he did not see that there'd be any connection between Jared's death and the defendant's and the victim's murder, so he did not do so. So there was that. And as the motion judge, I correctly found on this that there was no basis for any lawyer, an ordinary fallible lawyer, or even a brilliant attorney to think that there would be anything in those reports, there would be any statement by this woman that Jared made statements before his death regarding having had anything to do with this murder. But
Let's assume for the moment the counsel was not ineffective for failing to do it. We still have the fact that now we have information which was not presented at trial from Garnham's girlfriend that said that he stabbed, we did it, in a context in which you have also corroborating evidence from his brother or the two witnesses called by the defense indicate that Garnham was very much involved in this and arguably was the stabber.
Well, Your Honor, and so the thing is that, and my sister argues that none of the Commonwealth's witnesses supported this idea that Jared was part of the stabbing. Actually, Kayla Lawrence, who testified for the Commonwealth, it's true the bulk of the evidence was that Jared was not part of it, but Kayla Lawrence, who testified for the Commonwealth, said that Jared was part of it. She placed him there. She said she was standing there and she saw all four of them pummeling and attacking, kicking, hitting the victim. And then they left and the victim was on the ground. We know the victim was drenched in blood because D'Alessandro and Machado turn up right after that and go to him, and he's drenched in blood, lying on the ground, barely able to move. So she puts him there. Now, it's true that and also the Commonwealth left.
Before we leave Kayla, and I'm going back to the other trial, where did Kayla say that she saw the four of them pummeling?
She's standing right by the driveway area, and she sees them all of them pummeling him in the backyard. So she has perfect line of sight, and she sees them all attacking him because she runs after. So first, according to her testimony, Etnid, Irving, and JC are the ones who dart ahead. So they get there first. Then Jared runs there too, and she gets there last. And when she gets there, she sees all four guys on the victim, Tegan. So that's her testimony. So we do have a Commonwealth witness putting him there. We also have in the prosecutor's closing argument, he says, look, the bulk of, he suggests, look, the bulk of the evidence suggests Jarrett wasn't one of the people, but it doesn't matter. Even if you believe he was one of the people here, we know that Etnid was one of the people. Numerous witnesses say that there was a person in a white shirt being as part of the attack. We have him at Grampy's holding a knife. We know he was the original chaser. We have his statements coming in to his uncle, yes, I got him. There's so much strong evidence here that he was one of the attackers, that the fact that we have another witness saying, oh, well, Jarrett says he was part of it, really doesn't help the defendant's case, especially because, as this court has already noted, in Ashley Spring's statements, in her police report, she says every time we talked about it, he said, we killed him. And even in her handwritten statement to the investigator, she says it was with a group of people when I stabbed him. This does not exonerate the defendant or even help the defendant. He was tried as a joint venture. It doesn't even help his case because it doesn't matter. It would matter. I would say this would be much more important to the defendant's case if Ashley had said, yeah, and he told me, the other guys, they left, or they absolutely, weren't part of this. They departed at some point, and I started stabbing him, or it was just me. There's nothing in Ashley's statement, nothing in the police report statements, nothing in the investigator's statement that says that.
Right, but your sister argues in essence that if the jury finds that Etnid was the stabber, we don't need to dwell long about intent to kill. But if Garnham was the stabber, the jury would then have to find that and he was the only stabber, then the jury would have to find that he shared that intent.
Right, and I think that goes really to another issue that my sister raises, and that I think is the argument that involuntary manslaughter instruction should have been given. So first, I want to also point out that before I get to that, I want to also point out that Jai's testimony, if anything, was far more helpful than Ashley Spring's testimony would have been, because Jai is the one who my sister is relying on largely in her reply brief, that he made a statement, or at least at some point in rebuttal testimony, it came through one of the officers, that Jai at one point said that Jared told him that he was stabbing him while the others thought he was just punching him. So, of course, that testimony is really what the type of testimony that my sister is looking for, and that would have not come out through Ashley Spring. At least there's nothing in her statements to the investigator or the police reports that would have come out. So, and based on we killed him, that's certainly not suggestive of that. But going to the question of whether or not, I think as your question goes to whether or not involuntary manslaughter instruction should have been given, and even assuming there had been some testimony that there's a question of whether or not it was Jared who stabbed him, whether or if it wasn't, and it wasn't Etnid. Regardless, given the ferocity of this attack, given the violence, he wasn't stabbed one time. This is not like, this is very different than the cases my sister cites. For one case, she cites involuntary manslaughter instruction given by wanton reckless conduct in a case in Commonwealth versus Tavares, where the defendant had a gun, and then his friend, joint venture, grabbed the gun out of his hand and shot the victim, and the victim died from that one single gunshot wound. The court in that case found, well, by wanton and reckless conduct, it could have been involuntary manslaughter because he may not have known his joint venturer was going to grab the gun and kill him. There's very different circumstances here. This wasn't one fatal stab wound. This was stab wounds all over the person's body, neck, head, torso. 13 stab wounds. This was an extended attack, not minutes long or hours long, but it was still an extended attack in the sense that there was 13 stab wounds, and there was also blunt force trauma. And although it was dark out, D'Alessandro testified a light came on in the backyard during this attack, and it was light enough when D'Alessandro and Machado approached to see the victim drenched in blood. So this is not a situation where this was one fatal stab wound where maybe the others who were there didn't see the defendant, the stabber put the knife in the victim. The victim was stabbed all over his body. There's not one case that I found where an involuntary manslaughter instruction has been warranted on this cruel and extreme of an attack, where there's actually not just one fatal stab wound, one fatal shot, but 13 all over different places of his body.
What do we do? Who was the one, by the way, who testified that Cruz said, "Did you get him?" and the defendant said, "Yes, I got him"? Was that?
So it was D'Alessandro testified that he heard this exchange between Irving Cruz, the uncle, and Etnid Lopez, the defendant.
So, I mean, this cuts both ways. The fact that Cruz is asking, "Did you get him?" One arguably said, well, it wasn't as clear that he did get him as you said, because Cruz is asking, "Did you get him?" And of course, you can also say, well, it was the defendant who said, "I got him."
It was the defendant who said, "I got him."
But it does cut both ways in terms of Cruz's statement, "Did you get him?" suggests that it wasn't absolutely clear at the time to people involved what was that he was being stabbed as repeatedly as you described.
I would take the statement, "Did you get him?" to mean, and I might be looking at this too, "Did you complete the job?" But that could be, I mean, that's what I take it. Did you get him? Because obviously this is an extended attack, so they know that they are attacking this person. And also, I would say it would be impossible, or I mean, I think it would be impossible for people to be part of an attack and not see 13 stab wounds going in and out of a person's body. That would require 26 motions, right, of in and out, all over the person's body, head, neck, and torso. If those 3 or 4 people are standing right there, let's say that, and clearly and also there's testimony that the victim was grunting, he was flailing his arms. This is not a case, I would say, with this type of attack where there's anything less than a plain and strong likelihood of death.
Now,
and when you have plain and strong likelihood of death,
Was he convicted? He was convicted on extreme atrocity and cruelty.
he was,
theories.
Your Honor, yes.
Is the Samito case still valid that says that the joint ventures don't need to know about that they're armed? It was from 1996.
That joint ventures do not need to know, I believe.
There's a conviction on extreme atrocity and cruelty.
I believe that's the case. I believe that's true, that you don't need to know that the other person has a weapon. And I know there's a 1996, well, yeah, there's a 1996 case, Commonwealth versus Smith, but that it's before the case that you're citing. I apologize that they say even if the defendant didn't know he had a knife, they knew he had other weapons. I don't think that has been changed, though, that law, as far as, yes.
Right, but it would go only to the issue of whether you share the intent.
Exactly, yes. Whether, yes, just to the issue of whether you should intent.
Just on intent.
Yeah. If there are no further questions from the court, I will rest on my brief. Thank you.